Hi, I'm Deanna Sittner, and this is EDL 850 School Law, Module 12 on tort liability. Tort liability is defined as wrongdoings that are done by one party against another. Tort claims usually involve state law and are based on the idea that individuals are liable for the consequences of their conduct. In the school context, teachers are liable for acts that may cause injury to a student while under the teacher's supervision. The two major categories of torts that are typically observed within the education type related cases are intentional torts and negligence. Those two broken down a little bit more. Intentional tort is an offense committed by an individual who intends to do harm to another person or understands that her actions may cause harm. Common intentional torts would be assault, battery, slander. Then there's negligence, which is failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. So in the classroom context, negligence can be broken down into 4 elements. The first is, does the teacher owe a duty to the student? Number 2, did the teacher breach that duty? Number 3, was the teacher's failure to fulfill her duty the cause of the student's injury? And 4, did an injury occur? So I'm going to go through some cases on tort liability. The first is Barnett versus Caldwell. In this case, a high school student, Antoine Williams, was engaging in some horseplay with another student. The teacher left the classroom unattended for a short period of time, asking another teacher to listen in on the class. Antoine and another student, while horsing around, fell to the floor, to the ground. This caused Antoine to dislocate his collarbone, which in turn lacerated a major blood vessel. He was taken to the hospital and was pronounced dead. So in this case, the court actually decided that the teacher was not held liable for negligence, nor the school. Basically, she was allowed to make the decision to leave her class. So while it clearly stated that this really isn't a wise decision, it was within her rights to make that decision. Therefore, while not a good idea, allowed her to not be held personally liable. In my district, a reactive stance would probably be an investigation into why the teacher was not in the classroom. This has come up from time to time and is definitely something that that occurs while it's known that that you should not leave your students alone. There are times where using the restroom or something of that nature does occur. Proactively, to keep this from becoming a problem, just having procedures in place for when a teacher does need to step out, to use the restroom or take a call or something of that nature, having a policy or a place, someone that you can have come in and cover you for a few minutes. Professional ethics, basically just having staff development and a policy. This is going to occur, so just having coverage for teachers when this does need to occur would protect schools in the chances that they would be sued for something that could happen in those few moments when a teacher is out. The next case is NM versus Anchorage School District. And in this particular case, a 6-year-old student who goes by the initials of NM to protect his privacy was being picked up at the end of the day, running to mom when he tripped on what was a clump of pine shrubs. Unfortunately, he fell right on these, and one of the sticks penetrated, went in through one of his eye sockets and entered his brain. He was left with injuries that permanently altered the rest of his life, with really debilitating types of injuries. The family sued the school district, winning a substantial amount of money in this case. That there should not have been something that could cause harm, as in the clump of pine shrubs, in an area where the kids would be running and was a high traffic area. In my district, reactive would probably be looking at why was there something on the grounds, in other words, a clump of bushes in an area that the kids would be running or playing or being picked up in this case. Proactively, I think just assessing the grounds, looking around at the different areas, making sure that anywhere that the kids could be playing, running, in transit from one place to another, that those areas would be well maintained and safe, so that those types of incidents would not be, hopefully, occurring. Professional ethics, just always having your grounds would need to be maintained and accessible, so children can be monitored in those areas, and that they're not going to be harmed from things that might be in that area that really shouldn't be. So just keeping an eye on those things and making sure those things are removed or taken care of. In the next case, Munn versus Hotchkiss School. In this case, 15-year-old Kara Munn was bitten by a tick while hiking on a forested mountain in China during a summer trip that was organized by the school. The tick actually transmitted encephalitis, which caused Kara to have serious neurological damage and leaving her permanently unable to speak. So in my school, in this case, actually, the jury did find in the case of the family, saying that basically the school should be responsible for looking out for students and their health and well-being while on a school trip. In my school district, reactive would probably be something along the lines of, should we be taking student trips? Usually, unfortunately, when something like this happens, it seems as though one incident often can really have a debilitating effect on whether or not we can do things. So I think that would probably be something that would right away be looked at. Proactively, I think that just doing research and gathering together safety precautions for things, trips, areas that you're going to, or places that you're going to be, passing along that information, making sure that parents and students are aware of any types of things that they may need to prepare for or be aware of in those situations, I think would make a big difference. Professional ethics, student field trips do require a lot of advanced planning and care to ensure that students are safe, and that does require some effort on the part of whoever's putting those trips together, and making sure that the information is passed along so that there is no question that the school and teachers did everything they could to make sure those students are safe while they're on that trip. In the next case, Bryant versus the United States, 3 young students at a New Mexico boarding school left the school premises without permission and subsequently were trapped in a snowstorm. As a result, they suffered extreme frostbite, and it required that each of the students' legs were amputated. In this case, I think that reactively in my district, right away the school would be looking at how those students were able to flee and why no one was actively able to see that that was happening. Proactively, I think really just having a good plan in place for supervision that ensures that students are always monitored carefully, especially when outside on the playground or those types of areas, would make a difference. I think sometimes I know we have problems with people who are supposed to be monitoring but not always doing a great job with that, and I think that is something that really has to be addressed frequently through staff development and by administration to make sure that staff are upholding, their responsibilities to make sure that they're monitoring students. Professional ethics, then supervision of students is imperative to the safety and well-being of students. So having ironclad policies on supervision and how that should be addressed would be something that the school would really benefit from having in place. Girard versus Monrovia City School District. In this case, a boy was killed in a traffic accident on his way home from school. The family alleged that the school had negligently enrolled the child in the wrong school. Therefore, he had to cross heavily traveled streets on his way home from school, causing the accident to happen. In this case, the jury did find that the district was not at fault, basically citing that once students have been released from school property, they no longer are to be held liable for whatever would happen to them on the way home. This was cited in quite a few of the cases as being kind of upheld in most cases. Reactively, my district, I think, would look at why the student was enrolled at the location that they were. That would probably be the immediate question, since that was the complaint of the family. Proactively, I think just following guidelines and boundaries. We have boundaries that are in place for our school district, and just following those, I think, would sometimes kind of help that to becoming a problem. So professional ethics, then students should be enrolled within the school boundary lines that their residence dictates, unless there's a reasonable cause for them to be in another location. But I do think that just having those types of basic plans in place would keep those types of problems from occurring. And then here are my references. Thanks for listening.